Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. There has been a lot of talk in the law recently about unconscious bias and implicit bias as infecting and sometimes distorting jury verdicts. And I understand that pretty well, I think. Basically, that there are some biases that you may not be consciously aware of, but still impact how you think and how you feel about a particular group of individuals. Now, other than your average white supremacist who is clearly beyond the pale, I don't believe most of us want to be thought of as biased or prejudiced in any way, whether it's about someone's religion or their ethnic heritage or the color of their skin. We should judge people on the basis of the content of their character, as Martin Luther King clearly described in his I Have a Dream speech. But I think we haven't all gotten there yet, and as a result, there needs to be some adjustment sometimes for people who do base their opinions and base their judgments on irrelevant factors. In 2022, there was a case that reached the Washington State Supreme Court on the issue of implicit bias. It was called Henderson versus Thompson, and it involved a trial where the issue was damages. It was an automobile accident where the defendant in that case admitted fault. Essentially came in and said, yep, I'm absolutely wrong. I did the wrong thing. I caused this accident, but I don't believe that I should have to pay $3.5 million in damages. Unfortunately, a lot of times people, or I should say insurance companies, hire the most toxic defenders that they can hire to run a case because they know that difficult attorneys are difficult to work with, and in many cases they sort of artificially suppress the amount of money that a plaintiff will get. And that's particularly true in situations where plaintiffs are represented by lawyers who don't like to try cases, who essentially take cases to settle them. I've always been blessed to work for law firms that never took a case to settle it. They didn't take a case that they were not willing to try to a jury verdict. And in that situation, because they had that reputation, when they did settle cases, they got much better results than people who could be bought off for pennies on the dollar. Well, in this Washington State case, the Supreme Court there announced a rule for how someone could get a new trial if they could make a prima facie showing that the verdict was impacted by unconscious or implicit bias or prejudice. And I think that was a good case, although the standard may have gone a little bit too far the other way. One of the things that I think you see from time to time in these cases, particularly cases involving state Supreme Court cases, is that the pendulum swings one way and then a little bit later it swings back the other way. It doesn't always swing back completely, but it tends toward the middle. And as a result, you wind up with rules that tend to be unworkable, getting changed by later subsequent decisions that the Supreme Court itself doesn't make, but that the lower appellate courts make and sort of rein in through the way they're applying that Supreme Court precedent, the Supreme Court precedent. And I think that's what we have to discuss today. This is the case of Sheila and Ronald Simbulin against Northwest Hospital Medical Center. So here's how our story unfolds. Sheila and Ronald Simbulin were the personal representatives of the state of Ronald Simbulin Jr., and they filed a wrongful death complaint against the hospital for medical negligence in the death of their newborn son. After 3 weeks, the jury returned a verdict in favor of the hospital. Relying on our Supreme Court's opinion in Henderson versus Thompson, the Simbulins moved for a new trial under Court Rule 59 on the basis that the verdict was affected by bias against their Filipino heritage and immigration from the Philippines. The trial court determined the simulants established a prima facie showing of bias and ordered an evidentiary hearing pursuant to Henderson. Because no objective observer could conclude that the verdict was affected by bias based on race, ethnicity, or country of origin, the simulants failed to establish a prima facie showing, and the trial court erred when it ordered an evidentiary hearing. Accordingly, we reverse and remand. So, they claimed that this medical center was negligent in the delivery of their child. And they say that the obstetrician, the delivery involved shoulder dystocia, which is where the shoulders get caught during the delivery. And he was trapped sort of in the birth canal. He developed anoxic encephalopathy. And as a result, he died the day after the delivery on December 10th of 2017. So following jury selection and motions in limine, the case proceeded to trial. They had a number of expert witnesses that testified on behalf of the simulants, and the hospital had an expert that testified on their behalf. The simulants expert said that she waited too long and she didn't perform a maneuver correctly. And the other expert said that she didn't do anything wrong. Now, interestingly enough, Tawari, who is the doctor who was involved, she was from India. She was born in India and immigrated to the United States. The simulants are Filipino immigrants. At the conclusion of the 8-day trial, the jury found Tawari was not negligent and returned a verdict in favor of Northwest Hospital. That happened on September 19th, 2022. On October 20th, roughly a month and a day later, the Supreme Court issued its opinion in Henderson versus Thompson. Relying on that precedent, they sought to get their trial court to give them a new trial. The court says, relying on Henderson, the simulants argued that combining defense counsel's conduct with the fact that Ron and Sheila Simulant testified through Tagalog interpreters, an objective observer could view race and/or national origin as discriminating factors in the verdict. The simulants contended that they clearly met the standard articulated in Henderson, which requires a prima facie showing that an objective observer could view race as a factor in the verdict. In opposition to that motion, Northwest Hospital contended the simulants failed to satisfy their initial burden. So following a hearing on the motion, the court entered a written order that granted the motion for an evidentiary hearing, and in this case, Northwest Hospital essentially appealed that order. Interestingly enough, he quoted Henderson saying that the trial court provided that the evidentiary hearing would presume racial bias affected the verdict and that the hospital would have the burden of proving that the racial bias had no effect on the verdict. And if Northwest Hospital failed to meet that burden, then a new trial would be ordered. The law in Washington State is that if you can't prove that bias didn't affect the verdict, well, then you have to have a new trial. That's a pretty hard standard. It is very difficult to prove something did not happen. You can prove that something did happen because you've got the proof in the result. But where you're trying to prove that something didn't happen, that's just a big jump to make. So the appellate court, in analyzing this case, they went back and they reviewed what happened in the Henderson case that essentially set the standard here. And in Henderson, the court explained the verdict was affected by racial bias and that when it does that, it's incompatible with substantial justice. Under the standard, the court must grant an evidentiary hearing upon a prima facie showing of evidence that, if taken as true, permits an inference that an objective observer who is aware of the influence of implicit bias could view race as a factor in the jury's verdict. The court explained that in Henderson, there was no reason to tolerate a lesser standard of justice in a civil setting than we require in a criminal setting. The Henderson court said this: "We hold that upon a motion for a new civil trial, courts must ascertain whether an objective observer who is aware that implicit, institutional, and unconscious biases, in addition to purposeful discrimination, have influenced jury verdicts in Washington State, could view race as a factor in the verdict." When a civil litigant makes a prima facie showing of sufficient to draw an inference of racial bias under this standard, the court must grant an evidentiary hearing to determine if a new trial is warranted. At the hearing, the trial court is to presume that racial bias affected the verdict and that the party benefiting from the alleged racial bias has the burden to prove that it did not. If they cannot prove that racial bias had no effect on the verdict, then the verdict is incompatible with substantial justice and the court should order a new trial. Well, this Henderson case can basically be understood as a case where the defense lawyer just went too far in his argument portion of the case and essentially injected race into it. So Janelle Henderson was a black woman and Alicia Thompson, the woman that hit her, was a white woman, and they were involved in a collision. She filed suit against Thompson and requested $3.5 million in damages. Henderson's trial counsel was a black woman. Thompson was a white woman. The judge was a white woman. There were no black jurors. The only black people in the courtroom were Henderson, her attorney, and her lay witnesses. Henderson testified that since the collision, the symptoms she experienced due to Tourette's syndrome had increased. The testimony of Henderson's treating physicians, family, friends, and family members supported her claims. 3 of Henderson's lay witnesses were black women, and those witnesses all used the phrase life of the party to describe Henderson prior to the collision. During closing arguments, defense counsel attacked Henderson's credibility and that of her witnesses with multiple appeals to racial bias. He described Henderson as confrontational and combative and not interested in the search for truth. Defense counsel then said, by comparison, my client took the stand obviously feeling, I think, intimidated and emotional. Thompson's attorney suggested that the only reason for the trial was Henderson's desire for a financial windfall. Thompson argued that the testimony of Henderson's family and friends was inherently biased and suggested that the 3 black witnesses shared a popular idiom to describe Henderson, and that was a sign of collusion. Well, the jury, after hearing all of this argument, awarded only $9,200 in damages. After the verdict, the record, Henderson was asked to leave the courtroom before the jurors returned. In effect, the jurors told the judge, we aren't coming out if that black lady is still out there in the courtroom. Well, that would certainly seem to indicate to me that there was some bias and prejudice on that jury panel, and you can understand how that would impact the verdict in her case. And indeed, that's what the Henderson court found, and they reversed the verdict because an objective observer could conclude that the themes and arguments advanced by defense counsel suggested Henderson and her witnesses were not credible because of their race. And considering the totality of the circumstances of the trial, an objective observer could therefore conclude that racism affected the verdict. And I think that's a legitimate understanding of what happened. The terms confrontational and combative evoke the harmful stereotype of an angry black woman. And the defense counsel's closing argument alluded to racist stereotypes of black women as untrustworthy and motivated by the desire to acquire an unearned financial windfall. And the defense counsel relied on stereotypes about black people and an us versus them description to undermine the credibility of Henderson and her witnesses. So it's pretty clear that the Supreme Court felt that this was over the top and gave them a new trial as a result. So this is the case that the Simbulans are claiming racial bias impacted their verdict. However, while there were no black jurors in the Henderson case, there were, by contrast, Northwest Hospital notes here that 15 of the jurors who were seated in this case, 3 identified as Asian, 1 as black, 1 as Hispanic, and 3 jurors reported that they were born outside the United States, so they were immigrants. Again, all of this goes to show that there was not much of a racial issue with the jury that the Simbulans had in their case, and as a result, the court here says, look, you didn't make the prima facie showing. There's nothing here from the jury or from the judge or from the closing argument. In none of the closing argument did the defense counsel rest its claims on race or on stereotypes, and as a result, they essentially told the Simbulans, hey, you lost on the medicine. We're sorry. That's just the way it is. I think this is a good analysis and a good opinion here by the Washington State Appellate Court. It's a good opinion because it drives home the idea that the standard of some showing of racial bias has to be a legitimate showing that there was some bias that pervaded the trial. You can't just get up there and say, hey, we're Filipino, and as a result, it must have been bias. And if you compare the two cases side by side, you can see this. In the Henderson case, there were no African Americans on the jury, but here there were plenty of people who shared an Asian heritage. And there were no other black people in the courtroom. The defense counsel consistently injected racial stereotypes. But over here in the Simbulan case, there's never a mention other than briefly of what people's national origin is, and there are no stereotypes in closing. In other words, it was a strained application of Henderson here. And the Henderson case is really a closing argument case about going too far when you're attacking witnesses on bias. And that just didn't happen in the Simbulan case. Fact of the matter is, Filipinos are some of the nicest people you will ever meet in the entire world. It would be very hard to find somebody who had a negative stereotype about Filipinos. I spent 3 years in the Philippines. I love the Filipino people. And a lot of times when I see someone who is obviously Filipino, I'll say mabuhay, which is hello. And when I leave, particularly if they're like a checkout person or a waiter or a server, I'll say salamat, because that means thank you in Filipino, in Tagalog. Again, the fact that they testified through interpreters, that may have been kind of difficult for the jury to follow, but the long and short of it is it didn't impact the verdict. Again, a good decision by the Washington State Appellate Court. If you have any comments, I'd love to hear them. Put them down below, or you can email me at the address above. If you have the opportunity today, do a kindness for someone. Make somebody's life better. Make your day better. And then come on back tomorrow. Join me down here at the beach. We'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.